5 years ago, key tenets of the Scottish Government's named person scheme were ruled unlawful by the UK Supreme Court. In this series of videos, we're speaking to those involved in the successful No to Named Persons campaign and taking a look back at that long road to victory. Speaking to me earlier was Jim Sillars, former deputy leader of the Scottish National Party. Jim, if you don't mind, what would you say was your immediate reaction when you saw your party talking about introducing this named person legislation?
Well, I didn't have a great deal of reaction because, I'm a retired, semi-retired perhaps, politician and a grandparent. And it was when I was going on Any Questions in Aberdeen, along with Kezia Dugdale and Hamza Yusuf. And I had noticed, obviously reading the papers, that there was a great deal of anxiety about this particular piece of legislation. So that was bound to arise in the questions. So I thought, well, I better go and look at the legislation so that I know what I'm talking about. And I'm Westminster trained legislator, and we were trained by Willie Ross, former Secretary of State for Scotland, very formidable parliamentarian, that you examined every line and every word. And when I looked at this piece of legislation, I was utterly astonished because the language that was used. Now, all words are ambiguous. That's why lawyers use lots of words to try and define very clearly. But I had never seen so many ambiguous words in relation to such an important subject as parents and their children. And then, as I read further down the Act, I found them trying to define these highly ambiguous words with even more ambiguous words. And that was the pattern right through this legislation. And of course, the logic of the legislation, as I read it, was that one day the named person would knock on the door of a household and say, I am the named person. I've got more responsibility for your child than you have. I have the right to enter, and here I am. And I thought, this is utterly ridiculous. So when we went on question time that night, and it was raised, I said to the audience, this has got something like about 135 clauses and so many schedules. It's totally ambiguous. It's highly dangerous. And, it should be either repealed or amended. And I realised that from the body language of Kezia Dugdale and Hamza Yusuf sitting beside me, that actually they were not aware of the way this thing was working out. And I began to wonder whether they had read the Act. So I've always been peripheral to the organisation because I've not been, a member of it on a day-to-day basis. But obviously, my position on question time brought an invitation from the organisation to speak at a meeting, which I duly did. I think Kevin McKenna was the other main speaker. And I then got a phone call from a very good friend of mine who was an MSP, really very angry at my involvement in this. And I actually said to him, have you read the legislation? And to my utter astonishment, he said, no. And I said, well, how is it possible that I've read the legislation and I'm in the wrong? You've not read the legislation, you've voted for it, and you're in the right. This is a ridiculous position, actually, to be in. And, from there on, whenever I was asked to do anything, I did so. My niece, who is a primary school head teacher, she phoned me very, very concerned about what her position would be if she was one of the named persons. And I said to her, well, has your trade union told you whether you've got immunity or not? Because what happens down the road, say 10 or 15 years' time, could you be sued by a child or a family who said that you had misconduct to their detriment during the time you were the named person? And she said, nobody's ever said anything like that to me. I said, well, you had better say I decline to be the named person until such time as I have an absolutely clear position with regard to my legal responsibility to the child and to the child's family. And the one thing she was very sure about, she did not want to be a person who was seen by the family to interfere in the family life with parental responsibility for their child. And I wasn't surprised that when it all went to the Supreme Court, then the thing collapsed. I suppose you could say that the ones who thought it up meant to do well. But we have a problem in the Scottish Parliament. There is so little expertise that legislation tends to be perhaps substandard. And the committee doesn't work the way Westminster committees work. And so you don't get the forensic examination of the legislation in Holyrood that you would actually get in Westminster. And I say I'm Westminster trained. And I realized that, yeah, they meant well, but it was a monumental error on their part. And they didn't seem to realize that it was a massive invasion into family life. And there comes a point where the state should not intervene in family life. We're not that kind of society and never have been and never should be. And I think they stumbled into this basically through legislative inability. And I was delighted when it got a knockback at the Supreme Court.
So you mentioned that obviously, you were retired by then. You weren't really involved in politics. How difficult was it for you then to think, right, well, I've got to stand up for this and get involved in a campaign that might take years and a lot of my time?
Oh, I've got plenty of time as a retired person. That was never the problem. I mean, the problem is how wrong this particular piece of legislation is and its effect, the power that it was giving to organs of the state in relation to family life. That's what my motivation was. I was appalled by it. And I would do everything I could within the limitations of my energy to actually stop that happening and to alert the public to what was happening. Because there's a disconnection between Holyrood and the general public. And that particular piece of legislation is a very good example of it. I don't think that as it passed through Parliament, with no one voting against it, the general public had any idea of what was actually involved in that particular piece of legislation until the campaign got going and started to tell people this is what it means in practice. And I noticed that when I started looking into it, that the government claimed that they had done consultation, and on this particular piece of legislation, they had approval. And I thought, well, who did you actually ask? Because as soon as the general public began to understand the implications, then there was opposition arising, because no campaign can succeed if it isn't drawn from support from the general public. And it was pretty evident that once people began to realize what this was all about, then there would have been something wrong with the consultation as well. And this is a fault that continues in the method by which the Holyrood Parliament and the Scottish Government actually operate.
Why do you think there was such a slow acceptance among politicians that the public weren't really on side with this?
Well, that conversation I had with my MSP friend, I think, shows that they really thought that they were doing good. And of course, a number of children are unfortunately abused in the home as well as elsewhere. And they thought, we have to tackle this. Now, that is a minority of children. And you have to tackle that, no question, but with the law and the government action. But somehow or other, they didn't seem to understand that not all children are in that position. Not all parents are bad parents. In fact, the vast majority of children are in a good home, and the vast majority of parents are good parents. I don't think that they actually looked at the legislation in a forensic way. And what are the consequences of this on parents and general households? I don't think somehow or other they weren't, because of their good intention, they weren't capable of actually looking at the act the way they should have done.
Now, you said earlier that that you weren't surprised by the judgment at the Supreme Court, but how relieved were you, particularly given it had been struck down by both courts of session?
Yes, well, of course, I was very happy. The fact that I'm a member of the SNP is really quite irrelevant. I've got no problem whatsoever in opposing policies that come from the party which elects the government, which I am a member, as it were. I've got no problem with that at all. I was absolutely delighted and not surprised, let me tell you. We are ill-served by the way the committee system operates at Holyrood. Very badly ill-served. And, the named person legislation was a classic example of it. And so at the end of the day, who decides about legislation? Who interprets legislation? It is, in fact, the courts. And I wasn't surprised that they found it defective.
Now, we know that even after that result was handed down, and the Supreme Court said that the key part, the data sharing provisions, were unlawful, the Scottish Government was still so keen to hang on to it, weren't they? And you gave a speech back in 2017 at a No to Name Person event in Edinburgh, telling Deputy First Minister John Swinney to stop digging. But it still dragged on and on, didn't it? Why do you think it took so long for them to give up the ghost?
I don't think it's so much arrogance in the full sense of that word. But all government ministers don't like to be found wrong. And the tendency, therefore, is for them to say, no, it's not us who are wrong, it's you who are wrong. We have the best of intentions, we've done our best, and we still think we're right. There's a lack of humility in the SNP Scottish Government. And I think that was a classic example that John found it impossible to retreat from an impossible position. And so, as it were, stuck to their guns, even although the guns had no ammunition in them.
But this really did unite people from opposite sides of the political spectrum. What about the campaign was it? What about named person was it that really drew people together on it?
I think it was the essence of the matter. that this was an incredible amount of state interference in family life. Because, you know, at the end of the day, why would you have a named person who couldn't instruct the mother and father of a child? If you're a named person and you have responsibility from that child from, age of birth right through to 18, then you are in a superior position in law to the parents. And I think most parents said, not in your life. This is ridiculous. And, this is beyond what the state should have any part in whatsoever. I think once people grasp, and that's, I think, to the credit of the campaign, that they got that through to the people, that this was an invasion by the state where state proxies would have a superior position to parents. And that was something that sensible people, founded in common sense, would in fact reject.
I think that's basically all the questions that I had, but is there anything else that you would like to add in which you think is important to mention?
Well, I think there's a general point arises out of the campaign that if people believe that legislation is not just wrong, but damagingly so, and that there is a line beyond which they believe the state should not go, that the mere fact of the legislation becoming an act doesn't mean that you have to say, I don't like it, but I'll knuckle down to it. And what that campaign proved is that even if it passes and becomes an act of parliament, it is still something that can in fact be reversed by public opinion. And that's the lesson that all sorts of campaigns should take from the name person one. I think they did a great deal towards us understanding that we have civic power against government in a democracy.
Yeah, and that's a great message to end on, I think.
Okay.
Jim, thank you so much for talking to us. Thank you very much.